All right, good morning, everybody. Welcome to the live Q&A for personal injury. I'm Ben Goody with Gravis, and we'll give it a second here for comments to collect. But I guess for starters, the reason we created this is, 99 times out of 100, clients who come in do not know the process of a claim. So whether you're represented or not, there are things you should know. Right from the start, right after a collision. First and foremost is always call the police. A police report will give basics. It'll give a date, it'll give a time, it'll mention passengers, it'll mention witnesses, it'll outline and diagram what happened during the collision, and it will mention a citation if one is given. It gives evidence that the collision occurred. The insurance company knows it happened, it knows that their insured was involved, and it lets them know who's at fault. So if there's ever a question of should we call the police, yes or no, let's handle this between ourselves, let's just contact our insurance companies ourselves, no reason to call authorities, always call the police. It sets you off on the right foot with your claim. So, all right, let's go to the comments. What do we have? Okay, should I ever speak with the insurance company? If it is your insurance company, the answer is yes. Your insurance company will, depending on your coverage, they'll be the ones you go through for your property damage. Because after a collision, the at-fault driver, their insurance company has to investigate. They're going to want a copy of the police report, they're going to want to speak with their driver, they're going to want to get all the facts before they what's called assume liability or accept liability. In other words, before they say, yep, we're at fault, we'll take care of you, they're going to do their own investigation, and that has a delay attached to it. So if you have your own coverage for the property damage, you're going to be going through your own insurance company, at least it's an option. It will be faster. They will typically respond a little better. And then what happens is, if your insurance company ends up paying for your property damage, they're going to turn around and speak with the at-fault driver's insurance to get reimbursed. So they'll take care of you, they'll fix everything, and then they'll take that total amount that they paid, turn around and get it from the at-fault insurance company once liability has been established or once they accept fault. But you really should never speak with the at-fault insurance company. In other words, the person who hit you, the person who caused the collision, there's really no reason to speak to them until you are done treating. In other words, if you're injured in a collision, you're going to go see whomever to get treatment. Once you're done, you can talk to them about your injuries and your treatment and all of your medical bills and all of your damages. Until that time, there's no reason to entertain any offers from them, because what happens is, usually one of two things. After a collision, the insurance company who's in charge of the person who hit you, they will typically either ghost you completely or they will bombard you with communications. They will email you, they'll text you, they'll call you. They are not your friends, truly. They have two interests. One is to protect their insured. In other words, the person who hit you, it's their job to step in front of them and protect them. A big part of that is paying for your damages. But their interest is also to minimize the amount they pay out. So, unfortunately, most people don't know what to do after a collision, and the only voice speaking to them is the insurance company of the person who hit them. They don't have your best interests in mind. They want to protect their company. They want to protect their driver. So the irony isn't lost on me. So they know you're there. They know you were involved. They don't need to speak with you about settling your claim before you're done treating. Reason being, you don't know how much your claim is worth or the value of your claim until you know all of your damages. And you don't know all of your damages until you're done treating. So oftentimes people will get a phone call from an insurance company saying, we heard you in a collision, we accept liability, I can offer you $500 today and we'll take care of all your medical bills on top of that. That may be a fair offer, but on a more likely than not basis, it is not a fair offer at all. You take $500 today, they pay your medical bills, maybe. But if you have a surgery recommended down the road, or you have prolonged treatment, or it's just taking you a long time to get better, once you sign paperwork and close your claim, it's done. So don't accept an offer from the insurance company. Don't entertain offers from the insurance company until you know the extent of your damages. And an advantage of hiring an attorney is we take care of that for you. There's a lot of, spinning plates in a claim. And when you hire an attorney, the only one you are focusing on is your treatment. The insurance company, your health insurance, billing with providers, property damage, those are all handled by the attorney's office, or you're helped with those by the attorney's office. Okay, yeah, a lot of information baked into that question. Okay, what's the next one? What should I do if the collision causes me to miss a lot of work? That's a good question. So if you miss work, you have what's called a lost wage claim. In other words, because of the collision, because of my injuries from the collision, I am missing work. The best way to build a lost wage claim is to have substantiating documentation from your providers. Your providers meaning your doctors. So if you go to the emergency room, or you see your primary care doctor afterwards, or your chiropractor, whomever, and you're unable to make work, speak with them about it. Or if you're having difficulties at work, speak with them about it. If they have in their records, based off of my evaluation, they should not go to work for the next X amount of days, or based off of my evaluation, they have limitations they should have on the work they're performing, it needs to be documented. You can't just get in a collision, decide not to show up to work for 2 weeks because of the collision, and then expect the insurance company to connect the dots. The dots are there, but when in doubt, everything needs to be documented, and lost wage claims or missed work is best proven and substantiated when it's from a doctor's recommendation. So, good question. How long do I have to file a lawsuit? Okay, so personal injury is a creature of state law. The law in Washington is not necessarily going to be the same in Idaho or Montana or Oregon, Utah, Connecticut. So in Washington state, you have 3 years after the date of the collision to file a lawsuit. Now, and if you go beyond that, in other words, if it's 3 years and a day, you've lost the right to file a lawsuit indefinitely, forever. So that's the amount of time you have to file a lawsuit. But that doesn't mean your claim has to be completed by then. I've had, there are some cases where they're still treating after 3 years. So you file a lawsuit to keep the claim alive. So the time limit is 3 years to file a lawsuit, not 3 years to have your claim closed. Good question. But yeah, that date, that 3 years, it's called a statute of limitations. That differs by state. They vary from 2 years to, I believe, 6 years across all 50 states. Good question. Okay. Aside from medical bills and property damage, what else is insurance obligated to pay for? A really good question. So every claim is divided into, well, you can simplify it by saying each claim is divided into 2 halves: special damages and general damages. Your special damages are tangible, they're out of pocket. My doctor, I went to the emergency room, the bill was this. I went to go see my doctor, the bill was this. I had 15 visits of physical therapy, my bill is this. The doctor recommended I purchase this thing to aid in my recovery. It cost this much. My lost wages were this much. Okay, those are special damages. General damages, also known as pain and suffering, are less tangible. The inconvenience, difficulty sleeping, driving anxiety, I can't get around my home anymore, I'm unable to do my own cleaning or yard work. These go to special damages, and that is definitely a part of your claim. It's a big part of your claim. That's what humanizes your claim. It's when you receive an offer from an insurance company, that offer needs to account for both. So yes, everything that's out of pocket, tangible, a receipt in your hand, a bill you received in the mail, and also the stress, pain, suffering, inconvenience you experienced, all part of your claim, definitely. All right. Another question, medical expenses. How do I know what my medical expenses will be if I haven't healed up all the way yet? Okay, well, you don't. It's, two circumstances really are appropriate for closing up a claim and getting ready to speak with the insurance company. The first is you've healed up. You feel exactly the way you did prior to the collision, you're better. The second situation is you've reached what's called maximum medical improvement, meaning I've gone to my doctors, I've followed all of their recommendations, I've showed up to all the referrals issued, and I'm still not better, but the doctors have said I'm as good as I'm going to get. That's called maximum medical improvement. So again, you have to reach one of those two before it's appropriate to talk about a settlement. Good question. Question here about, PIP. I have health insurance. Do I need PIP? This is a better question for your insurance agent. So if you're driving, you walked into an agent's office or you phoned an agent and purchased insurance from that company, or you purchased a policy from that company. In Washington State, by law, you have to be offered PIP. It stands for Personal Injury Protection. They have to have that rejection in writing, or they have to offer it to you. In other words, you walk into your agent's office, they offer you PIP, you say no, you have to say no in writing, they have to prove that you said no in writing, or they have to give you PIP. So the purpose of PIP is to pay for your medical bills. You walk into the hospital, you walk into your doctor's office, chiropractor's office. If you have PIP, PIP will pay your medical bills until it's gone. How do you know it's gone? It depends on what you paid for. If you bought $10,000 worth of PIP, that means your auto insurance company will pay the first $10,000 of your medical bills through PIP. Once that $10,000 is gone, then you need to look to your health insurance. Health insurance will not pay any of your bills until PIP is gone. The question was, if I already have health insurance, why do I need PIP? PIP is wonderful, especially in the state of Washington. PIP will pay your doctors dollar for what they bill. What does that mean? If I walk into my doctor's office and it's $300 for a visit, my health insurance is contracted with my doctor's office, and maybe they're going to pay them 50% of that. Okay, so the doctor bills $300, my health insurance pays $150. PIP will pay dollar for dollar. Your doctor bills $300, PIP will pay $300. So it's a preferred method of payment for any and all providers. So it's a great way to get in the door somewhere that doesn't accept your health insurance. PIP is also good because there are some providers, there are some areas, there are some networks that if they know you've been in a collision and there's a settlement somewhere in the distant future, they will not bill your health insurance for the reasons we just talked about. They don't want 50% of their bill or 40% of their bill. They want 100% of it, and they will wait for the settlement. PIP gives them that right away. So again, if you're dealing with a provider that you prefer and they will not accept your health insurance or don't want to bill your health insurance, PIP is a great way to still be seen by them. When represented by an attorney, there's a built-in, I won't call it a bonus, but there's a piece of state law that says your PIP has to share the burden of you hiring an attorney. In other words, the costs and fees. So, out of your settlement, you have to pay back health insurance, PIP, whomever helped you pay for your medical bills. So if PIP paid $10,000 of your medical bills, you need to pay them $10,000 out of your settlement. If you're represented, they have to take a reduction. So just by virtue of hiring an attorney, the PIP you have to pay back decreases by approximately 1/3. Same thing with health insurance, most health insurances. There are special plans that don't have to participate in that chunk of state law, but for the most part, labor and industries, health insurance, PIP, they all will have to reduce their subrogation by a certain percentage when you have an attorney. So PIP covers medical bills. It covers medical bills in a way that's very favorable to providers. It allows you to see providers that your health insurance may not cover. So great question. A lot of people have questions about PIP. Okay. Is it possible for my insurance to cut me off from treatment even though I have PIP? That's getting into the weeds. Health insurance and PIP work a little differently. PIP is a contractual benefit that you purchase through your auto insurance. Health insurance is a different beast. The short answer is one or both may start to wonder if all of your treatment truly is necessary. And there are ways for them to investigate that and potentially cut it off. But that's a great question. That could take up most of this hour. So I encourage you to reach out to me or somebody else at Gravis, and we can get into that in detail. That's a really good question, though, because especially with labor and industry claims, a lot of times labor and industries will say, okay, I think you're done. Let's get you in front of a doctor, get you evaluated, so they can give us an opinion on whether or not you need more treatment. They're called IMEs, independent medical examinations. They're quite common, but again, that could be a subtopic in and of itself. I would definitely speak to an attorney if your insurance company or labor and industries or PIP is trying to get you into an IME. That's definitely a good time to speak to an attorney. Okay, let's see. Ooh, this is a really good question, especially in Washington State. What happens if I'm hit by an uninsured driver? So depending on who you listen to, Washington State has between 18% to 33% uninsured drivers. I mean, no way to know for sure. There's different studies, different demographics, different numbers, but the point is it's quite high. So in other words, at any given time you're driving through Washington, 1 out of 5 to 1 out of 3 drivers don't have insurance. So if you're hit by somebody who does not have any auto insurance, that's when you need to have what's called uninsured motorist coverage. In other words, if you're speaking with your auto insurance agent, they have to offer this to you too, by the way. And they say, do you want uninsured or underinsured motorist coverage? And you say, well, what is that? Exactly the situation. I'm out driving, somebody hits me, they don't have any insurance. You're out of luck unless you've purchased uninsured motorist coverage. That means your insurance company will step into the shoes of the adverse insurance company to take care of you, to fix your car, take care of your medical bills, take care of your pain and suffering, etc. So again, underinsured motorist or uninsured motorist, you need to be offered it in Washington. You have to have a rejection in writing, but not legal advice, but just because of the statistics attached to Washington, a very, very good idea to have or add uninsured motorist coverage or underinsured motorist coverage to your policy if you don't have it. I've had people walk in the door who don't have coverage themselves. Their driver didn't have coverage and they were hit by somebody who didn't have coverage. In that circumstance, there is literally no insurance to go after for a settlement. There's no claim to be made because there's no insurance involved. So to help protect yourself from drivers who don't have insurance or don't have enough insurance, I definitely recommend speaking with your agent about underinsured or uninsured coverage. Underinsured works the same way. It says, what if I'm hit by somebody They have insurance, but it's not enough. What do you mean it's not enough? You know, when you purchase auto insurance, you purchase limits. For a certain amount of money each month, the insurance company will give you coverage up to a certain amount. So in Washington State, the legal minimums are $25,000. That's $25,000 per person involved, $50,000 per collision. What that means is if I'm hit by a driver and they have minimal coverage, the most I'm going to get out of their insurance company is $25,000. That could work out just fine if you only have $5,000, $10,000 in medical bills. It might be horrible if you have to be life flighted and your helicopter bill is $80,000. There's not enough insurance. They are underinsured. So if you have underinsurance coverage through your own provider, through your own auto insurance, that helps cover any additional damages you may have on top of that person's policy. So, and even if it's not a dramatic or serious collision, just a trip to the emergency room could drain your PIP, and it might take up, it might be, I guess what I'm trying to say is it's very easy to find yourself in the middle of a claim that exceeds the at-fault driver's policy limits. You're in trouble pretty quickly of not having enough to make yourself whole. So, good question. All right. Oh, this is a good one too. What if I was a passenger in a vehicle that was in a wreck and I get hurt? Do I have a claim? Yes, you do. And you'll have potentially multiple levels of coverage. In other words, I'm in a car by myself, I get hit by somebody who's in a car by themselves and they own the car, there might just be one insurance that I'm going after. But if you're a passenger, so insurance follows the driver. So if you're hit by a car, that the owner of that car's insurance is who you go after first. If the driver has a different policy, that's the second insurance you'll go after. If you're hit by a driver and you're a passenger, if you're hit by another car and you're a passenger in the car that was hit, you have access to the owner of that car's policy, the driver of that car's policy, and if those aren't enough, you actually have access to the driver of your car's policy and your policy. You could have several layers of insurance, and this is all good because the more insurance policies are available, the greater chance you have of getting a fair settlement that truly puts you back in the position you were in prior to the collision, or as best as possible. So yes, short answer, if you're a passenger in a collision, you have a claim. Whether you're in the car that caused the collision or did not, you have a claim. It just depends on what coverage is out there. But yes, you do have a claim, definitely. All right. Aha. What are your contingency fees like, or do they vary? Good question. So when you hire an attorney, it's industry standard in personal injury that the attorney's fees are 1/3 of the settlement. So whatever the settlement is, 1/3 of that goes to the attorney's office for representing you. That causes people to pause quite a bit. So just a heads up, statistically, cases where an attorney has been hired or retained tend to fetch 3 to 3.5 times more in settlement, and approximately 80% of the monies paid out by insurance companies are paid to people who are represented. So hiring an attorney is a great way to make sure you're getting a fair offer and that all the moving parts are taken care of, that everything has a bow on it, and you can walk away knowing your claim was really worked up to the maximum dollar amount possible. So each office may be a little different. It's not uncommon for you to walk into an attorney's office, hire them, the agreement is, okay, 1/3 of your settlement, unless we have to file a lawsuit. Then the fees might go up. Maybe it becomes 40% if we have to file a lawsuit, 45% if we have to arbitrate, 50% if we have to go to trial. The reason being is after you file suit, the case becomes much more expensive. It extends the life of the claim, or can extend the life of the claim. by several years, and every step of litigation has a price tag to it. So, short answer is the fee is 1/3 of the settlement, and it may increase with litigation. Good question. Do I pay taxes on my settlement? For the vast majority of all cases, the answer is a very simple no. Why? Why is your settlement not taxable income? Your settlement is not taxable income for the most part. Well, for most cases. When I say most, I mean, I think I've come across one in my time practicing. So the reason it's not considered taxable income is because it's not considered income. You're not being paid something. You're being reimbursed. You're being made whole. So the collision, if it helps, think about the collision as putting you in a hole. The purpose of the settlement is to bring you back to where you were prior to the collision. So it's making you whole, putting you back in the same position prior to. There's no gain, okay? Part of that whole is your pain and suffering. So it's not just being reimbursed for your medical expenses, it's your pain and suffering, and once both of those have been taken care of, you've been made whole. So it's not taxable income. If you want to go into the weeds on when your settlement might be considered or is considered taxable income, or part of it is considered taxable income, give me a call. That's a really good question. Super rare, but I'd be happy to go into it with you, let you know. Okay. My friend's car was totaled from a pothole. Huh. You're from Spokane? Can an attorney help them with that? Yes and no, it depends. The correct answer, legally speaking, is always it depends. Just speaking from experience, most personal injury attorneys handle just that, personal injury. If you total your car from a pothole and there's no injury and there's nobody else at fault for going through the pothole, I won't speak for most attorneys, that's not a case that I would take, because what you're dealing with is straight property damage. My car is totaled. So if your car is totaled from a pothole, you need to look to your insurance coverage, speak to your insurance agent, see what coverage you purchased, and see if it covers that damage to your car. But generally speaking, what if I parked my car on the side of the street and it was hit by somebody during the night and they totaled it? Okay, there's no injury. The car was empty. It's just property damage. Again, personal injury attorneys handle personal injury matters. Some of them, myself included, I will help you through a property damage claim, because if you're in a collision, your car's damaged and you're hurt, there's two separate claims. Okay, you'll have a property damage adjuster, you'll have a personal injury adjuster. You can settle your property damage claim before your personal injury, no problem. One does not affect the other. But if there's no injury associated with the collision and nobody else to blame, it's usually not a case, well again, I'll speak for myself, that's not a case that I would take. There needs to be somebody at fault, another insurance company involved, and personal injury involved for a personal injury attorney to be interested in the case, typically. Okay, good question though. Let's see, I have this is really good point, really good question. I have a pre-existing condition. Is this covered? Is this covered meaning, can it be included in the claim? You bet. So legally speaking, the insurance company has to take you as you are at the time of the collision. So if I'm 20 years old and perfectly healthy versus 86 years old with advanced something or whatever, doesn't matter. The way the collision affects you is the way the collision affects you, and that has to be, it's acknowledged as part of your claim. So I will say that if you have a pre-existing condition, you need to have what's called an identifiable injury, and that's for any claim. So to simplify it, this is totally hypothetical. If I have back pain, and let's say my back pain is at a 4 out of 10, and then I'm in a collision and my back pain is at a 9 out of 10, Okay, that's an identifiable injury. I went from being 4 out of 10 to 9 out of 10 in pain. In theory, your injury from the claim has been resolved when your pain is back down to a 4. In other words, the injury caused a spike in your pain of 5 out of 10. So when that's addressed and you're back down to baseline or where you were prior to, that's what the other driver is responsible for. Now that's an oversimplification. If you have an exacerbation of 4 to 9 and it caused, it has a domino effect and it requires other treatment, we'll get into the weeds on that. If you come into the office, we'll talk about what's related and how and if. But in general, if you have a pre-existing condition, yes, any identifiable injury on top of that is part of your claim. Good question. Okay. Ooh, what should I do if the police won't say who was at fault at the scene of a collision? Okay, and that happens. They show up. There's no independent witnesses to speak with. It's he said, she said. So if they're not willing to put in a police report who's at fault and write a citation at the scene, one, don't worry about it, at least not yet. Depending on where your collision occurs, there might be video footage. Certain counties and certain areas, there are cameras at intersections. So if your collision is at an intersection and the other driver says they're not at fault, you say you're not at fault. The police officer says, well, I can't figure out who's at fault. We can check video footage. Another way, so when police respond, they gather information and they write a report. It can take some time before the report is ready. So if they can't make a decision at the time of the collision, at the scene of the collision, we can always wait for the police report. Again, oftentimes they check video footage, they'll speak to people who are witnesses or claim to be witnesses and try and piece it together. So the short answer is let it breathe. The long answer is if there's no way for the police to tell and there's no way to identify who's at fault legally speaking, you may have a dead-end claim. But good question. So a piggyback question about camera footage. How do I get that? Is that something an attorney requests? They should. Depending on where the collision occurs, will determine who you contact for video footage. So that's kind of going into the weeds because the answer will vary depending on where you are at, whether it's Department of Transportation or a county or a city. I've had some collisions where we're able to request private video footage. You're driving by a business and the collision occurs and that business happens to have cameras pointed at the road. So again, the correct answer is always it depends, but your attorney should definitely investigate that. Good question. Oh, okay, question about some vernacular that the insurance company might use or words they'll use. Third party versus first party. The third party insurance company is the insurance company of the person who's at fault. First party is when you use your own insurance. So this is important because, like most things that have specialists or subspecialists, there's words and phrases that they will use that are unfamiliar to the public. So whenever you're talking about insurance companies or insurance carriers, and if they're third party or first party, they come with their own set of things to watch out for, circumstances where you should speak with them, circumstances where you shouldn't. There's different rules they have to play by. So just in case that ever comes up, third party, for the most part, means the at-fault insurance, or the insurance of the at-fault person. And then first party would be your own insurance coverage. Okay. All right. How long do I have in the state of Washington to settle a claim with, oh, here you go, somebody's paying attention, with a third party insurance carrier? So again, The statute of limitations, or the time limit to file a lawsuit, is going to be 3 years against a third party. In other words, against an at-fault driver's insurance company. But the question asked, how long do I have to settle a claim? Technically, there's not a time limit. It settles when it settles, but you do have to keep an eye on when you have to file suit to keep it alive. Now, if you're dealing with a first party, in other words, your own insurance company, that changes the statute. So, real life scenario, well, hypothetical real life scenario. I'm out driving, I get hit by a driver who is uninsured. They don't have insurance. But I have underinsured motorist coverage, so I'm covered. Okay, you don't have insurance, shame on you, but I can look to my own insurance company, present a claim, and they'll take care of me. That has a totally different statute of limitations or a time limit on it. It's 6 years in Washington. So this is getting into the weeds a bit. A third party claim is a claim under negligence. A first party claim is a claim under contract. I have a contract with my insurance company, and part of that contract is my uninsured or underinsured motorist coverage. So if I have a claim against my own insurance company, the statute of limitations on that is going to be different than if it's against another driver in most states. It varies by state. So again, all of this is a creature of state law. So this is for Washington. Oh, this is a good one. Can social media be examined in my personal injury lawsuit? Well, if I understand your question, are you asking if your social media posts and pictures and videos can be used as evidence against you? It most certainly can. So it's a good idea after a collision or after you're injured to really be careful about what you post. I mean, I just wouldn't post anything, because what you post can be discoverable. If you ever do get into, if you ever do file suit on your claim, your Facebook posts, your, I guess whatever platform, your posts, your pictures can be requested and used against you. So if you're claiming that you have a back injury or a shoulder injury that prevents you from leaving your house or going to work, but then you have pictures of yourself on Schweitzer, it doesn't line up. So the short answer, yes. So use a tremendous amount of common sense after a collision or after your injury when it comes to your social media. Good question. Why hire an attorney? I like the brevity. So touched on it a little bit. People walk in the door and we'll talk about their collision and they'll say, it's not about the money. It really isn't. And part of me says, sorry, but it has to be, because at the end of this, that's all you're going to have to show for it. No judge or jury or settlement for that matter can take you back to the position you were in prior to the collision. They can't take away the driving anxiety. They can't give you the sleepless nights back. At the end of your claim, the only thing you'll have to show for it is a check. So it has to be about the money. And statistically, the best way to maximize the value of your claim is to have an attorney represent you on that claim. Touched on this a little bit too. There are a lot of moving parts to every claim. There's health insurance, there's PIP, the police are involved, there's witnesses, there's doctors, there's the other insurance company, there's deadlines to keep track of, there's filings, there's what's called subrogation. We talked about that a little bit. That's where you have to pay back people who have paid for your medical care, or if you go out on disability, they are entitled to be paid back. So there's a ton of moving parts. Hiring an attorney means that attorney and his or her office are keeping track of all those moving parts and making sure they're handled correctly, handled in a timely fashion, they're paid the correct amount when everything is said and done, they're paid timely. I mean, let's be honest, it's something you can do on your own, but there's a lot of places, I mean, there's a lot of moving parts where not knowing how to do it correctly can cost you. That will cost you. So, good question though. Do you only handle us, or you meaning us meaning Gravis, do you only handle automobile accident claims? No. So car collisions are just a part of personal injury. There's slip and falls. If you're at somebody's business or you're out at a restaurant and you injure yourself there, you may have a personal injury claim under what's called premises liability. Dog bites. If you are bitten by a dog and you have damages from it, that's another subsection of personal injury. Wrongful death. If your death was caused by the negligence of another, that's another personal injury claim. So if you think of personal injury as a circle, and then there are other kind of mini Venn diagrams around it. Medical malpractice, wrongful death, dog bite, premises liability. Those are all included. So if you've been injured and you think it's because of the negligence of another person, that is personal injury in a nutshell. Good question though. What type of information do I bring with me to my consultation? Everything, anything you have. Bring your health insurance information, bring your own auto insurance information. It's called a declaration page or a deck page. So when you go to Geico or State Farm or Country Financial or whomever and you purchase a policy, it should be summarized in what's called a declaration page. Liability. If you're liable for a collision, these are your limits. Collision, these are your limits. PIP, these are your limits. If you're looking at your insurance, either online or in paper, and you see that information, that is your deck page. So bring your deck page, bring any photos you have of your car, any photos of your injuries. If you have bruising, if you have any scarring, you're in a collision, you hit your head on the steering wheel, you have scarring, definitely take pictures of any scarring, especially permanent scarring. Bring in any medical bills or provider notes you have to date, if you have them. Bring in, if you've received text messages from the other insurance company, bring those in so we can take a look at them. Emails, correspondences, pretty much anything you've received or taken a picture of since the collision or from the collision, bring it in. It could all be important. Bring in an exchange of information. After a collision, a lot of people think an exchange of information is a police report. It's not. The exchange of information is exactly that. It's your information and the other driver's information on a sheet of paper, and you're both given a copy. It's an exchange of information. It gives basic details on who was involved, who their insurance coverage is, what they were driving, that sort of thing. So short answer is everything. Okay. Can you file for your child if they were involved in a collision? Okay, so we'll go back a little bit. If your kiddo is involved in a collision, they have their own claim. But because they're a minor, there's special rules that have to be followed. So getting straight to your question, the short answer is yes. If your child is involved in a collision and they have an injury, if they're involved in a collision, they have a claim. They can file on that claim. They can file suit on that claim. That'll get into the weeds a little bit. So if you're asking specific about your child in a certain collision, come on in. I will I'll discuss it in greater detail with you, but for the purposes of this, the short answer is yes, they have a claim. Can an attorney help with a hit and run? Yes. So if you're involved in a hit and run, so in other words, if you're out driving and you're hit by somebody and then they leave, what happens? Well, if you can get their information, a license plate, really a license plate, they can be tracked down to that hit and run. It turns into pretty much like any other claim. You have an identifiable or identified at-fault person, and we go after their insurance. Okay, what if it's a hit and run and you don't know who they are and you can't find out who they are? So this is another reason or another circumstance when it's important to have uninsured motorist coverage. In other words, I was just hit by somebody, they took off, I don't know who they are. It's called a phantom vehicle claim, and it falls under your uninsured motorist coverage. So the short answer is an attorney can help with a hit and run, but depending on if you can identify the hit and run driver or if you can't, will determine what type of claim you have. But in both circumstances, there's going to be moving parts. And just because you're going through your own insurance company doesn't mean you don't or you don't need or shouldn't have an attorney. Your insurance is still in the shoes of the adverse party. In other words, they want to take care of you. They have to take care of you contractually, but it's always a good idea to be represented to make sure they are treating you fairly. Okay. We kind of covered that one already. So more of a comment, less of a question. So going back to a typical circumstance, I'm in a collision. One of the first phone calls I get after is from the insurance company of the person who hit me. So speaking broadly, most of the time the offers they present are not fair offers. In other words, when they say, yeah, we'll give you $500 or $1,000 and we'll take care of all your medical bills, whether or not they're trying to cheat you, I won't comment on that, but it's inappropriate to talk about settling a claim until you know what all of your damages are going to be. So if I go to the emergency room and I've seen my primary care doctor and I'm seeing a chiropractor and it's only been a week after the collision, I mean, how do they know what they're offering me is fair if, in 2 or 3 weeks I'm still not better and my primary care doctor thinks I need to see a physical therapist or thinks I need to see an orthopedist or thinks I need to see a neurologist? If you accept a settlement, I mean, at any time, whenever you accept a settlement, it's done, it's over. It cannot be reopened, your claim is over. So if you take $500 and they pay your medical bills, but 6 months later you're still treating, a year later you're still treating, your claim's already closed. So again, just to reiterate, it's inappropriate, in my opinion, for insurance companies to try and settle personal injury claims while someone is still treating, because the extent of their damages isn't known. It's still ongoing. So, I mean, I tend to agree with the tone of the comment, but just to flesh it out a little bit. I was involved in a collision yesterday. What should I be doing right now? Good question. So we talked about it a little bit. Always call the police, take photos, go see a provider. If it's an emergency, go to the emergency room, urgent care, primary care doctor. It's always a good idea to at least be checked out after a collision. So, I mean, you should be receiving care if you're injured. It's very bad to be in a collision and then wait 3 weeks before you go seek treatment. Delays in treatment and gaps in your treatment, meaning, okay, I started today, I went for a little while and then I just stopped going for a couple months, but then I went back. That's a gap in treatment. Delays and gaps in treatment damage your claim. Because again, what we're looking for is identifiable injuries. So if I'm injured today and I get it documented today and I get treatment for that without any interruptions, it's a much more solid claim than if I'm injured today, I go in and see a doctor in a few weeks, and I kind of do treatment off and on until I'm better. So what you should be doing today or right now is making sure you're taking care of yourself with treatment. And again, if you choose to hire an attorney, that's the only thing you should have to focus on, because all the other moving parts are being taken care of by the attorney. All you focus on is your treatment, seeing your doctor and other providers that have been recommended at the frequency they've recommended with the treatment they've recommended. I mean, your choice on what treatment to pursue, but the most important thing for you to do is to seek and get the treatment that is recommended until you're better. Good question. I had somebody come into the office after a collision on their way to the hospital. I recommend going to the hospital first. Honestly, I'm not going anywhere. I'll be there. Seek treatment. That's the most important thing. You're welcome. So, I guess I'll touch down on policy, on insurance policies just for a little bit while the rest of the questions come in, or the remaining questions of the remaining time come in. It's really important to take a look at your own insurance coverage before you drive. There's technically no such thing as full coverage. What I mean by that is there's no set definition for full coverage. Sometimes people will walk in and say, I'll ask them, well, do you have PIP? Do you have uninsured motorist coverage? They say, yeah, I have full coverage. And I get nervous automatically, because legally speaking, full coverage is what's required by law, and that's only liability coverage in the amount of $25,000 and $50,000. Full coverage could mean the legal minimums plus underinsured motorist. It could mean a whole host of things. So if you're thinking in your mind right now, I have full coverage, I'm good, go look at your declaration page. See what that means. If you're unsure what it means, talk to your agent. If your agent can't give you an answer that you're happy with, I'm happy to take a look at it too. All my consultations are free. I'm happy to walk people through claims. If you don't hire an attorney, I'll be more specific. If you do not hire me, I can give you generalizations. I can't give you legal advice. As you noticed today, nothing about today was about legal advice. It's about educating on what to do and how to do it and what to look out for. So if there's any recommendation at the tail end of this, it's to take a look at your coverage and make sure you know what you have, because you don't want to be surprised after a collision. Like, wait a minute, I thought I paid for that, or I thought that's what that meant, and it turns out to be not so. So if you have a claim and you need help on it, give me a call. If you don't have a claim, and you don't know exactly what coverage you have through your auto insurance, give your agent a call and go through the deck page with them, line by line, truly. Because if you do not have coverage and the other driver does not have coverage, in most circumstances, hire an attorney may or may not actually help the situation. Because if somebody hits me with their car, I'm going after their insurance policy. I'm going after their coverage amounts to be made whole. I'm not going after their home or their retirement, or their cars. Some people are worried about that. Well, I don't want to sue them. I'm not that kind of person. Well, we're not. We're going after their insurance policy, and their insurance policy is going to pay you and that's what they paid for. They paid for insurance in case they caused a collision. You know, same thing with your own insurance. If you end up using your own insurance for PIP or for underinsured or uninsured coverage, you paid for it. Use it. A lot of people are worried, saying, well, I don't want to use it because then my rates will go up. When you're in a collision, whether you're at fault or not, that collision will go on your record. It's called a CLUE report. It's illegal in the state of Washington for your insurance company to raise your rates because you use PIP or underinsured or uninsured motorist coverage. They can still raise it. It'd just be very unwise for them to put in writing, we're raising your rates because you used your PIP. And I tell people, if your insurance company is going to do that to you, guess what? There are a lot to choose from. So be aware of what policies mean, be aware of what they cover, and thanks for joining.